My dear students, welcome back to our channel. In this video, I will be explaining the Bcom second semester subject Business Laws as prescribed by Osmania University and other universities of Telangana. We will go through the important questions and answers one by one. Let's begin with a quick revision. Unit 5 first important short question is winding up of a company. Winding up means closing a company permanently. It is a legal process where the company stops all its business activities, pays off debts, and distributes any remaining money or assets to shareholders. After winding up, the company is removed from the register and stops existing legally. There are two main types. 1. Voluntary winding up, when the company itself decides to shut down. It may happen if the business is not profitable. 2. Compulsory winding up, ordered by a court, usually when the company can't pay its debts. Example, if XYZ Ltd. is not earning profits and wants to close, it can apply for voluntary winding up. But if ABC Limited has many unpaid loans, a creditor can ask the court to wind it up compulsorily. Winding up ensures that all legal formalities are completed and no loose ends are left. It protects creditors, investors, and the company's reputation. Easy tip: think of winding up like switching off a business forever, with all bills cleared. Next important short question is 2. Voluntary winding up of a company. Voluntary winding up means a company itself decides to shut down its operations legally. It is not forced by a court. This usually happens when the company is no longer profitable or the owners don't want to run it anymore. There are two types. 1. Members voluntary winding up, when the company is solvent, can pay its debts. 2. Creditors voluntary winding up, when the company is insolvent, can't pay its debts. Steps: company passes a special resolution to wind up. A liquidator is appointed to sell assets and pay debts. After clearing everything, the company is officially closed. Example, if Sunrise Pvt Limited is not doing well in business and the owners want to close it, they can pass a resolution and apply for voluntary winding up. Easy tip to remember: in voluntary winding up, the company says, "I quit," before anyone forces it to stop. Next important short question is 3. Compulsory winding up. Compulsory winding up means the court orders a company to shut down. This happens when the company does something illegal, cannot pay its debts, or works against public interest. When does it happen? The company fails to pay debts. Company breaks the law or acts fraudulently. Company does not file reports or start business within a year. It's just and fair to close the company. Who can apply for it? Creditors, if money is unpaid. Shareholders. The registrar of companies. The central government. Example, if XYZ Limited takes loans and fails to repay them, the creditors can request the National Company Law Tribunal, NCLT, to wind up the company. The tribunal may pass a compulsory winding up order. Easy tip to remember: in compulsory winding up, the court says you must stop because the company didn't follow rules or pay debts. Next important short question is 4. Insolvency and Bankruptcy Code 2016. The Insolvency and Bankruptcy Code, IBC, 2016 is a law made by the Indian government to help companies and individuals who are unable to pay their debts insolvent. It gives a time-bound process to either restructure or shut down such businesses. The goal is to protect creditors, save failing businesses, or close them quickly to avoid more losses. Key features: A company must be resolved within 180 days, can extend to 330 days. Creditors can apply to the National Company Law Tribunal, NCLT, if a company doesn't repay. A resolution professional, RP, manages the process. If resolution fails, the company is liquidated, its assets are sold. Example, if ABC Limited cannot pay suppliers and banks, the creditors can go to NCLT under IBC. Either ABC is revived with a plan or shut down. Easy tip to remember, IBC 2016 is like a doctor for sick companies, it tries to save them or close them fast. Next unit 5. Long questions. First important long question is: explain about various modes of winding up company. Winding up of a company. Winding up means closing a company's operations permanently and distributing its assets to pay off debts. It is the legal process through which a company comes to an end. After winding up, the company is removed from the register of companies and stops existing. There are three main modes of winding up. 1. Compulsory winding up by tribunal. This happens when the National Company Law Tribunal, NCLT, orders the company to shut down. Some common reasons. The company is unable to pay its debts. The company has acted against the interests of the country. The company has not filed financial statements or annual returns for 5 years. Just and equitable to wind up. Example, serious disputes between directors. Example, a company fails to pay salaries or debts for months. The creditors approach NCLT and the company is compulsorily wound up. 2. Voluntary winding up. Here, the company decides to close on its own. This can happen when the goal of the company is achieved, when the company wants to avoid future losses, when shareholders pass a special resolution to wind up. Example, a real estate project company completes all its projects and decides to close formally. 3. Winding up under Insolvency and Bankruptcy Code, IBC, 2016. When the company is insolvent, can't pay its debts, creditors or the company itself can file for corporate insolvency resolution under IBC. If revival is not possible, the company is liquidated. Example, a manufacturing company can't repay its bank loans. It is taken to the NCLT under IBC and gets wound up. Summary to remember. Mode who initiates reason. Compulsory winding up tribunal, NCLT, legal violations, debt or disputes. Voluntary winding up company itself project completed or to avoid losses. Winding up under IBC creditors or company unable to repay debts, insolvent. These processes help protect creditors and ensure fair closure of a company. Next important question is: 2. What is the procedure of winding up by the tribunal? Procedure of winding up by the tribunal. Winding up by the tribunal, also called compulsory winding up, is a legal process where a company is closed down under the order of the National Company Law Tribunal, NCLT. This happens when the company is not functioning properly, can't pay debts, or is involved in unlawful activities. Step-by-step procedure. 1. Filing a petition. A petition is filed before the NCLT. This petition can be filed by the company itself, creditors if debts are unpaid, registrar of companies, central state government, any person authorized by the government. Example, a creditor files a case because the company failed to pay loan installments. 2. Notice to the company. The NCLT sends a notice to the company and asks for a reply. The company can accept or defend itself. 3. Hearing and order. NCLT holds a hearing. If the company has no valid reason, the NCLT may order for winding up. 4. Appointment of liquidator. The tribunal appoints a company liquidator. The liquidator's job is to take control of the company's assets, settle debts and liabilities, sell the assets if needed, prepare final accounts. 5. Submission of reports. The liquidator submits a final report to the tribunal showing how the assets were sold, how the money was distributed. 6. Dissolution order. Once everything is completed, the NCLT passes a final order for dissolution. The company is now legally closed, and its name is removed from the register of companies. Easy to remember example. A company took a loan but failed to repay for years. The creditor goes to NCLT. After checking the documents and hearing both sides, the tribunal winds up the company, appoints a liquidator, assets are sold, and the company is closed forever. Summary. Start, petition is filed. Middle, tribunal checks and appoints a liquidator. End. Assets are cleared and company is dissolved. This method ensures a fair and legal closure of companies that cannot continue. Next important long question is 3. Enumerate the consequences of winding up of a company. Consequences of winding up of a company. When a company is wound up, it means the company is legally closed and its business ends. It no longer carries out any operations. All its assets are sold, debts paid, and whatever is left is returned to the owners. Key consequences of winding up. 1. End of business operations. Once winding up starts, the company stops doing business. It can only continue work required for closure. Example, a mobile company stops selling phones after winding up is ordered. 2. Appointment of liquidator. A liquidator is appointed by the tribunal. His job is to take control of assets, sell the assets, pay off debts. 3. Company assets are frozen. The company cannot sell or transfer its assets. Only the liquidator can manage them. 4. Employees lose jobs. When the company shuts down, all employment contracts end. Employees may get compensation if funds are available. 5. Legal cases continue under liquidator. If there are any pending court cases, they now continue in the name of the liquidator. He represents the company in legal matters. 6. Payment of debts in order. Debts are paid in a fixed order. First, secured creditors, like banks. Then, employees' dues. Then, unsecured creditors. Last, shareholders, if anything remains. 7. Company's name removed. Once all debts are settled, the liquidator sends a final report to the tribunal. Then, the tribunal passes an order of dissolution, and the company's name is removed from the register of companies. Easy example. Imagine a textile company that can't repay loans. The tribunal winds it up, appoints a liquidator who sells all machines and buildings. He pays the bank loan first, then the workers. After all dues, the company's name is removed from official records. Quick tip to remember. Winding up is equal to business ends plus assets sold plus debts paid plus name deleted. It is a legal and final process of closing a company properly. Next important long question is 4. Under what circumstances company name can be removed from the registrar of companies? Clearly demonstrate. When can a company's name be removed from registrar of companies? The Registrar of Companies, ROC, has the power to remove a company's name from the official list if certain conditions are met. This process is called striking off. This usually happens when a company is not working or inactive for a long time. Circumstances when a company's name can be removed. 1. Company fails to start business. If a company is registered but doesn't start its business within 1 year, the ROC can remove its name. Example, ABC Ltd was registered in 2022 but did not begin operations by 2023. ROC can strike it off. 2. Company is not operating for 2 years. If a company is not active for 2 financial years and hasn't filed application to become a dormant company, its name can be removed. Example, XYZ PVT Ltd didn't do any business from 2021 to 2023 and didn't inform ROC. It can be struck off. 3. Voluntary application by company. A company can apply itself for name removal if it has no liabilities. All shareholders agree. It is not involved in legal cases. Example, Definite PVT Ltd is not in use anymore, has no debts, and directors want to shut it. They apply under Section 248(2). 4. Company's documents found to be false. If it is found that the registration was done fraudulently or by giving false information, the ROC can remove the name. 5. Company doesn't file returns. If a company doesn't file annual returns or financial statements for 2 years, it is treated as inactive and name can be removed. Important section. This removal is done under Section 248 of the Companies Act, 2013. Easy tip to remember. Strike off happens when no business plus no returns plus no activity. Final note. After the name is removed, the company stops existing legally. It cannot do any business, sign contracts, or go to court. It's like the company was never born. Removing a company's name helps clear inactive or fake companies from records. Next important long question is 5. What are the exceptions for Insolvency and Bankruptcy Code 2016? The Insolvency and Bankruptcy Code, IBC, 2016 is a law that helps companies and individuals resolve their financial problems when they are unable to pay debts. But this law does not apply to everyone and in all situations. There are some exceptions. Let's understand these exceptions in simple and easy words. 1. Banks and insurance companies are not covered. The IBC does not apply to banks, insurance companies, financial institutions regulated by RBI, IRDA or SEBI. Example, if a bank like SBI has financial issues, it won't be resolved under IBC. Special laws like Banking Regulation Act apply instead. 2. Government companies in strategic sectors. Companies working in defense, atomic energy, and other strategic areas are not covered by IBC unless the government allows it. Example, a company making missiles for Indian Army cannot be forced into insolvency under IBC. 3. Micro and Small Enterprises, MSEs, some relief. MSEs are given relaxation in some rules under IBC. This helps protect small businesses and gives them more time or easier procedures. 4. Personal guarantors and partnerships handled differently. Earlier, IBC was for companies. Now it includes individuals and partners, but rules for them are not fully active yet. They are handled under different timelines. 5. COVID-19 relief, temporary exception. Due to COVID-19, The government temporarily suspended insolvency proceedings for defaults between 25th March 2020 and 24th March 2021. This was to help businesses survive the pandemic. 6. Minimum default amount 1 crore rupees. The law applies to companies only if the unpaid debt is 1 crore rupees or more. So, small defaults are not covered under corporate insolvency. Easy to remember line. IBC helps solve big money problems, but banks, defense, small firms, and COVID cases get special rules. Final thought. These exceptions ensure that essential sectors and small businesses are not burdened by IBC. It keeps the system fair, balanced, and practical.